Anyway, I see we're getting to a critical mass. So let me begin. Hi, I'm Ken Stern. I'm the director of the Bard Center for the Study of Hate. Um, I'm very thankful for your participation and your attendance at this webinar today, and I'm delighted to have Nadine Strossen and Richard Wilson to share their thoughts with us on the subject of law and hateful speech, what is to be done, which is a broad topic, and we're not going to be able to cover all aspects of it, obviously, in an hour, but I think what you will hear from them will be very illuminating. And so I'm delighted to have them both here today. What we're going to do is they're going to speak for about 35 minutes, or actually it's going to be the easiest webinar for me because they're going to talk to each other and I'm going to bow out. But in about 35 minutes in, we'll start taking questions and answers. And what you can do is you don't have to wait for that part of the meeting. If you have questions you want to ask, put in the Q&A box. I'll remind people again after they finish speaking, and I will moderate the questions for both of them. So let me give some introductions. Nadine Strossen is the John Marshall Harlan Second Professor of Law at New York Law School, and she's a leading expert on constitutional law, civil liberties, and international human rights. She's the immediate past president of the American Civil Liberties Union, first woman to lead the nation's largest and oldest civil liberties organization. And she now serves on the advisory boards of the ACLU, EPIC, which is the Electronic Privacy Information Center, FIRE, the Foundation for Individual Rights in Education, and Heterox Academy. When Strossen stepped down from the ACLU as president, three ideologically diverse Supreme Court justices participated in a farewell tribute luncheon. Ruth Bader Ginsburg, Antonin Scalia, and David Souter. She's been named one of America's 100 most influential lawyers. She's had several publications. Her most recent book, which I highly recommend, and I will hold up for you, is called Hate, Why We Should Resist It with Free Speech, Not Censorship. And it's a fascinating read. And I'm also very delighted to say that Nadine kindly contributed the forward to my most recent book, which I was delighted about. So Nadine, welcome.
I'm delighted to be here.
Thank you. And Richard Wilson is the Gladstein Distinguished Chair of Human Rights and Professor of Law and Anthropology at UConn School of Law and the founding director of the Human Rights Institute at UConn. He's a scholar of human rights and transitional justice who is currently teaching courses on law and society, post-conflict justice, and an interdisciplinary graduate level course on anthropology, history, law, and philosophy of human rights. And he's also the Associate Dean for Faculty Development and Intellectual Life, which I'm sure the university is benefiting from, but I don't envy him all that work. He's the author of editor of 11 books on international human rights, humanitarianism, truth and reconciliation commissions, and international criminal tribunals. He wrote the definitive ethnographic study of the South African Truth and Reconciliation Commission. His book, Writing History and International Criminal Trials, was selected by Choice in 2012 as outstanding academic title in the law category. And his latest book is called Incitement on Trial, Prosecuting International, thank you, Nadine, because I don't have it. Prosecuting International Speech Trials, I don't have it with me. Explains why the International Criminal Tribunal struggles to convict individuals for inciting speech and proposes a new model of prevention and punishment. But I will hold up a recent law review article that I commend to you too from Connecticut Law Review called Hate Speech on Social Media Towards a Context-Specific Content Moderation Policy. So with that, I welcome you both. I know you have figured out how you're going to go and question each other. So I'm going to turn off my video and leave it to you guys. So welcome and
Thanks,
thank you.
Ken. See you later.
Thank you, Ken. Thanks very much. It's an honor and a privilege to be sharing a stage virtually, albeit with Nadine Strossen, who I just have so much admiration for. So I just want to start by asking you, Nadine, if you wanted to summarize the main themes of your book, which again, I'll show people buy this book. It is an excellent defense of freedom of expression and a review of the main arguments for and against regulating hate speech. So please summarize for the audience the main themes of your book, what drove you to write it, and if you also wanted to give us an idea, because it was written 3 years ago, which I feel like I've aged 30 years in those 3 years. But the things that have happened since that you would want to lead on to after the book.
But that's a tall order, Richard, and I definitely want to hear from you. So, bang on a glass if I go on too long. Before I answer that excellent question, though, let me say that it's really a delight to be here. I have such admiration for both Ken and Richard. Ken, I don't know if everybody in the audience knows this, really he's the founding father of the field, the interdisciplinary field of hate studies. And Richard and I have been collaborating so often with respect to, among other things, our last 2 books. We both spoke at each other's book launch at the Open Society Foundation, and I continue to learn so much from you, Richard. And then I have to salute Bard College. I've had the privilege of speaking here multiple times. I have great memories. I hope you notice I am wearing your school color. I always try to do that, especially if it's a color that I like. So thanks for your color choice. Now, on to the book. I was propelled to write this book, Richard, despite the fact, maybe because of the fact that I had written and spoken so much on the perennial controversies over hate speech. It's always been controversial, even in the United States, with our strong free speech tradition. I was president of the ACLU, and the most famous or infamous case the ACLU has ever handled, which I was asked about every time I spoke or did an interview, was the so-called Skokie case from the late 1970s, when the ACLU successfully came to the defense of the free speech rights of neo-Nazis to demonstrate in Skokie, Illinois, a town that has a large population, not only of Jewish people in general, but of Holocaust survivors in particular. Now, we lost 15% of our card-carrying members, people who care so passionately about free speech that they forked over the really cheap, I should say, membership dues. That was a little plug. But seriously, so when I hear today that, the atmosphere has become so much more hostile to free speech, college students want to censor hate speech, I say, look at all those decades ago, when it was the many decades older ACLU card-carrying members who thought that we went too far in a case that was a slam dunk winner in terms of free speech principles. So you can win in the court of law, but not in the court of public opinion. And then decades went by, and it's starting around 2015 with the upsurge of, to me, welcome upsurge of campus activism against racial injustice, for Black Lives Matter, against police abuse. These were issues I had been crusading for a long time. And it was really wonderful that students were, after decades of being rather apathetic, suddenly really engaged in social justice causes. That was, music to my heart. And yet a sad tone was the constant criticism and growing criticism of free speech. And I started to feel that I had to try to make the case again. Clearly, I and others who had argued fervently that freedom of speech, including for hate speech, is ultimately especially important to advocates of human rights, especially important to minority groups and minority opinions. We hadn't made that case persuasively enough. And so I set out to try to persuade a younger generation. That said, Richard, I did my level best to be open-minded. open to evidence that could change my mind. I think everything is subject to reexamination. I heard the title of a book on my one of my talks was at Skidmore College, and the president of that college was writing a book, which he gave me permission to quote the title. His name is Philip Glotzbeck. He's a political philosopher, and the title of the book was, what would it take you, or I'll put it reflexively, what would it take me to change my mind? And I thought that is such a powerful question, because unless you're talking about a matter of religious faith, we should all be able to answer that question. So I believe, along with the United States free speech law, that freedom of speech is not absolute. Government may restrict speech if it can satisfy an appropriately heavy burden of proof, if it can show that the restriction is necessary to promote a countervailing goal of compelling importance. So if I were convinced that suppressing hate speech more than is already allowed under US law would be necessary or even effective to promote equality, to counter hatred, to counter discrimination, I would be in favor of that. And more importantly, US law would be in favor of it. But the evidence that I read from all around the world throughout history reinforced my prior understanding that no matter how well intended anti-hate speech laws are, they are at best ineffective in countering the underlying attitudes of hatred, and at worst counterproductive, paradoxically amplifying the voices of those who disseminate hatred. So that's a very rough summary. I think I'm going to add one brief point, which is, discouraged as I was about the track record and ability of censorship to counter hatred and promote equality, I became much more encouraged than I had been before about the power of other measures, including counter speech, anti-discrimination laws, laws against hate crimes, and against discriminatory violence. I have great hope that we can achieve progress toward human rights through those non-censorial measures. Now, before I get to ask you the same question, what's changed in the last 3 years? The law review article that you wrote together with your colleague Molly Land, which Ken referred to, touches on one of the major changes, which is that the major source of suppression of any kind of controversial speech in the recent past, including hate speech, is not government. It's social media companies. The other major source of suppression of controversial speech is what's often referred to as cancel culture. And what both of those forces have in common is that they are exercises of free speech by private sector actors who are not bound to respect anybody else's free speech. So not only do we not have a constitutional remedy available to protect ourselves against the censorial forces of cancel culture and social media restriction, but their free speech rights would be violated if there were attempts to suppress those forces. So that means we really have to be very creative and imaginative in looking at other ways to promote a free speech culture. Free speech law is not enough to protect the actual exercise and enjoyment of free speech. So that took 9 minutes, 8 minutes. I was timing myself. I hope that you will spend at least as much time answering those questions yourself.
It's mercifully, you were very succinct, given that you spent years writing the book, and it's always painful for an author to summarize in 8 minutes what they spent many years working on. But I'll try and be as succinct as you were. So I wrote the book Incitement on Trial because I was fascinated by the propaganda trials at international tribunals. There were 2 at Nuremberg, and many at the International Criminal Tribunal for Rwanda and the former Yugoslavia and the International Criminal Court. And so I looked at these 30 or so trials, and I found the first thing that struck me about them was the high level of acquittals. So the conviction rate for war crimes at these tribunals was around 95%. But they're only convicting about half of the defendants at these international tribunals. And we can see that at the Nuremberg trials, where they convict and hang Julius Streicher, the Nazi propagandist, but they acquit Hans Fritz, who is the deputy minister to Goebbels in the Ministry of Propaganda. And that shows the ambivalence that international tribunals have had towards suppressing and regulating speech. Now, that ambivalence is well-grounded. There are countervailing forces here of freedom of expression on the one hand and protection from harms on the other. But I think if we look at that, that 24 plus trials that I examined in the book, we can see that there are a bunch of problems in prosecuting individuals for their speech acts alone. Most of these individuals participated in no other way in genocide and mass atrocities except by encouraging others to carry out a series of heinous acts. And the problems are as follows. First of all, the law is not very clear. International criminal law is not very clear. It's not clear on whether there needs to be a causal connection between the speaker and the subsequent violence that occurs. How close does that causal nexus have to be? The second problem is just logistical, and that is getting testimony from eyewitnesses and material perpetrators that they heard the speaker, and that's why they went out and committed these violent acts. So, the judges tangle themselves in knots in some of these decisions. And I try and point out how they fall back on tired cliches like, so-and-so lit a match to a tinderbox, or their words were like the bullets in the gun. And here, when judges start to wax lyrical like that, my antenna go up. And I get skeptical and I get worried. If they're reaching for cliches, it means they may not know what they're talking about. So, I was very critical of that, and in the book, and I come to a series of recommendations. I say, let's have very clear law and guidance on the type of speech that is prohibited and the contexts in which it's prohibited. Because you can't just look at the Speech Act. You have to look at what's happening around this. And I believe our First Amendment law does this as well. It insists on the importance of context. And what kind of contexts are the kind of contexts in which an incitement to violence may lead to violence? Well, a speaker who is in a high position of authority, a history of intergroup violence between the groups concerned, an audience that is whipped up and emotionally very intense, a speaker using very graphic language, dehumanizing the other. So those are some of the elements that we need to be looking for, and they are actually listed in the international law of speech regulation and the Rabat principles, which we can talk about more if you're interested. And so finally, I said, let's reserve international law for the speakers who say things like kill group X, and not suppress merely offensive or reprehensible speech. Let's just go for the cases that are most worrying. And in contexts where that speech is most likely to cause problems, or there is a clear link between the speaker's incitement and what happened next. And that connection has to be very tight. So that's what I was getting at. I think there are a lot of overlaps in our books, but you're talking about US law, I'm talking about international law. And so one of the questions I would throw back to you is that the US First Amendment law is usually viewed as exceptionalist in its strong protection of hate speech and other types of controversial speech. And this stands apart from some of the other advanced democracies like Germany or Britain or France. Is this view accurate? Are there justifications for the US strong protections on speech? Should we be a little bit more like the Germans in this regard? Or is the exceptionalist position one that you would like to defend still?
Well, thank you so much, Richard. And I think I would like to clarify for the audience a point that you stress at the beginning of your book, but you didn't have time to do here, which is that the international hate speech crimes that you're talking about are of a whole different order of magnitude from what we're talking about in any domestic law, including Germany and France and other countries that strictly protect hate speech, right? You're really talking about incitement to genocide. So the answer to the question, first, why is the United States so strongly protective of free speech? That's the first part. And then I think it's not so exceptionalist, but it is so strongly protective recently, going back to the 1960s, which is ancient history from the student's perspective, but from the perspective of a First Amendment that goes back to 1791, it's really quite recent history. Until that point, the Supreme Court was no more speech protective than European courts are now, and did allow speech to be punished if it had a so-called bad tendency or harmful tendency. You did not have to show the tight and direct connection between speech and imminent, serious, specific harm, which the court started to insist upon in the 1960s. Any speech that could potentially indirectly at some indefinite future point lead to harm could be suppressed. And when you think about that, it's not surprising that with such discretionary power, because after all speech could potentially lead to harm, even what you and I are saying here. That gave license to whoever was enforcing the law to selectively punish particular speakers or particular messages just because they were unpopular. And not surprisingly, that discretionary power was consistently used, as is true for hate speech laws in other countries, disproportionately against the very minority voices and people that are hoped to be protected by anti-hate speech laws. And that's why all crusaders for human rights throughout US history have opposed censoring hate speech. That was true for the civil rights movement, and it's true today for many human rights activists in other parts of the world. So it is true that our free speech law is much more protective appropriately than it had been in the past, than many other countries are in the present. But what I only fairly recently learned, and have become an enthusiastic propagandist for this knowledge, that international free speech law, specifically under United Nations treaties that have been ratified by almost all countries in the world, is surprisingly speech protective and surprisingly similar to US law. And you mentioned the Rabat Plan of Action, which is one, it's not a treaty, but it has significant persuasive power. And it does reflect the same core idea that we have in US free speech law, that there has to be tight and direct causal connection between the speech and the harm, in particular violence or discrimination, before the speech can be suppressed. So let me throw it back to you, Richard. I reread portions of your book to prepare for this because I find it so fascinating. And what is especially interesting to me is your expertise as a social scientist, an anthropologist in particular, and your reference to studies and evidence from social science, or I should say lack of evidence, about the purported connections between even the most vitriolic, hateful speech and actual violence. So I think most people think, oh, it was Nazi propaganda that led to the Holocaust. Everybody knows that it was radio propaganda that led to the Rwandan genocide. And yet you tell us that, according to social science, these are misconceptions.
Yeah, so there were strong assertions made in the wake of the Holocaust, that it was Nazi propaganda that convinced the German population to go along with Hitler's plan to exterminate Western Jewry. And similarly, after the Rwandan genocide, the question is always asked, well, how could this happen? How could a population act so callously and so genocidally against members of their own community and nation? And so propaganda is the easy thing to reach for. But the studies didn't really bear this out very strongly. So social science studies of a qualitative and a quantitative kind came up with mixed results. And so when I was writing the book, I couldn't help point this out, that the social science evidence does not support the strong mechanistic view of propaganda, that you just have this input into people's minds and then they go off and act in a way that is violent or even genocidal. I think one can make a weaker argument on the basis of the social science data, which is that propaganda creates an atmosphere of tolerance for violence. It creates a greater willingness to go along with a genocidal project. It vilifies a target group. It reduces empathy for that group. So I think there are these broad umbrella effects, but the one-to-one billiard ball, A hits B hits C, is not the way we should think about it. Now, since I wrote that book, there has been a lot of evidence on the relationship between hate speech on social media and offline consequences. And here, what's interesting is that they can really get at big data. We're talking about millions and millions of posts. And then the researchers, and if anyone's interested, they can email me and I'll share you their names, but Muller and Schwartz in Germany, Relia in the United States, and then others, have found that actually you can find correlations between online hate speech and offline hate crimes. Those are correlations. They're not the same as causation, and they don't create necessarily a certain set of policies that flow from that. But I think we do have to recognize that there is a relationship, but it's not the one-to-one causal relationship that a criminal court demands. It is a much more diffuse and indirect set of relationships. Sorry if I went on too long about that, but I actually teach a whole course on this stuff. So that was the 14-week course in 2 minutes or 5 minutes or however long it took.
But that's really fascinating. And in the offline media, there isn't even a correlation, right? That was what I was surprised to read, that in Rwanda, there wasn't even a correlation between where people had access to radio and where most of the killings took place. And my research also, because I'm just passionately committed to finding what would be constructive ways of negating hateful attitudes, but at the very least negating hateful actions. And over and over again, I read that it's not through persuasion of any kind. So a lot of people are discouraged when they read studies that show that if somebody believes a conspiracy theory or other disinformation, giving them the facts is not necessarily going to change their mind. It might just entrench their attitudes. That's the bad news. The good news is that you've got to work it from another perspective. You build a trusting relationship with that person and get them to question their own views and, or form other connections. And there are famous case studies of former hate mongers who have been redeemed, or they've redeemed themselves through empathetic, trusting relationships with other people. But you can't, putting them in prison doesn't work. Ostracizing or stigmatizing them doesn't work. Giving information doesn't hurt. We have to look for these other strategies. Well, you've brought up the what you called the coiffed elephant in the room indirectly, Donald Trump and social media deplatforming. That was such a great figure of speech. So in terms of before we even get to the social media issue, I think you talked a lot about the concept of incitement. And even though you think that the US standard is, you agree with me that it's, of course, very demanding, you wrote an excellent op ed recently arguing that Trump has satisfied that standard. And what was so interesting, Richard, is just a couple of years ago, you wrote another op ed involving a case that actually went to court alleging that Trump had incited violence against some counter demonstrators at one of his campaign rallies. That was rejected. The judge said there's a First Amendment defense. But you think the facts are different now. So maybe you could
Yeah.
compare. Yes.
So I never wanted to be in the position of defending Donald Trump, but there was a lot of talk and chatter at the time in 2016 when he ran, and also when there was the shooting at the Sayanock bombings, and then the shooting at a synagogue in Pennsylvania, and everyone was pointing the finger at Donald Trump and saying he incited violence. And I said, look, his speech is reprehensible and offensive to me personally and to many others, but it doesn't meet the Brandenburg standard. And I just wanted folks to understand that. So that he had not directly incited violence, it had not done it so in an imminent way, and that it was not necessarily probable that his words would then incite violence. However, I think that changed on January 6th. And I wrote an op-ed, which was in the LA Times on January 7th, arguing that he had, in fact, incited insurrection under 18 US Code, section 2383, in the speech where he encouraged the audience to fight 20 times, fight like hell, don't show weakness. Members of his entourage referred to trial by combat, that they said Republicans were coming for you. We have to ask the question, how did the members of the audience react? Well, they took it as instructions from him personally. They said to journalists as they stormed the Capitol, we're doing this under the instructions of our president. They said, we are hunting for Pelosi. We're going to hang Mike Pence. So the authority of the speaker, the emotions of the crowd, the way in which the speak was intended and then taken up indicates a strong and compelling argument for incitement to insurrection. And I believe the Attorney General's office will look into this. I believe the DC District Attorney is also looking into this. So I think there were reasons to convict Donald Trump in the Senate. Remember that the Senate is not a criminal trial. It actually refers to high crimes and misdemeanors. So the prosecutors didn't need to satisfy the Brandenburg standard, because Donald Trump could have simply said, I don't respect the Constitution anymore and I'm not going to abide by it. And that speech alone, while not a crime, may have led the Senate to rightfully charge and convict him, because he was not upholding what he had sworn to uphold. So I think there was strong evidence. Then there was, at the same time, the deplatforming. And so I want to ask you whether you thought the deplatforming of Donald Trump in the days after the trial, taking him off social media, depriving him of, 90 million followers on Twitter, whether that was the right call by the social media companies, and whether or not they ought to let him back on, now that the moment has passed.
Okay, may I first comment on the incitement question? And
Sure.
first of all, I think we have not told everybody what we mean when we refer to Brandenburg.
Yeah.
Is the Supreme Court's unanimous 1969 decision in an ACLU case, I'm proud to say, where it rejected the former bad tendency test, and for at least in this context, adopted a very strict general emergency test, but as Richard alluded to, specifically requiring that for speech that allegedly induces other people to engage in lawless or violent conduct, you have to show that the speaker intended to incite, and incite is used as a term of art. The court says advocacy of violence is constitutionally protected. It's only incitement of imminent violence where the speaker intends to incite imminent violence and it's likely to happen. A very strict test, but one that I think arguably could be satisfied by the facts on January 6th. I think they're, as you said, Richard, all of these tests are appropriately very fact specific. And I think it would behoove the fact finder, whether a jury or a judge, to examine in detail all of the contextual facts. And I would also say that if it is found that this is incitement because of some of the unique factors that you stressed, the uniquely powerful position of the president, the uniquely adulatory attitude of his followers, and so forth, that would really have to be stressed, because I think it would be really dangerous if the strict standard were watered down, because it then would be used, as it mostly has been used, against social justice activists. The ACLU had a case in the Supreme Court just last year on behalf of a leader of Black Lives Matter movement who had been held culpable in the lower appellate court in the United States Federal Appellate Court, simply because he organized and spoke at a BLM protest where some unknown assailants injured a police officer, and the police officer successfully sued him. And that, to me, is inconsistent with Brandenburg. So I don't want to water it down. Now, on the issue of deplatforming, I'm going to say something else unpopular. Oh, by the way, I hasten to add, I have no love lost for Donald Trump, but I love the First Amendment even more, and free speech even more than I do not love Donald Trump. So, and I'm so constantly aware of the history of and the potential reality of, we lawyers say hard cases make bad law, right? Or even so, I'm always worrying about the ramifications. So, to me, the power of the platforms to take down expression about political issues of urgent concern that is coming from supposedly the most powerful elected official. Let's not forget, he was still holding elected office. Some of us might have wished he wasn't elected, but he was elected through a democratic process, deprived of a very special, important opportunity to reach his millions of followers. And freedom of speech pertains not only to the speaker's right to convey information and ideas, but also to the right of audience members, his opponents as well as his supporters, who choose to hear that speech. In a democracy, there is no speech more important. Where we, the people, wield sovereign power, how can we wield it in an educated, informed way if we don't hear what these powerful officials are saying? And interestingly enough, many analysts say that one of the crucial factors in Trump not being elected was the incendiary disinformation that he was spewing forth on social media. And analysts say that that turned around enough suburban voters who had voted for him last time around. So we can't assume some simplistic relationship that his speech will be more harmful if it's allowed to be heard. It might actually galvanize people to vote against him. And in particular, I'm really, my heart doesn't bleed for Donald Trump. He obviously has megaphones other than Twitter and Facebook. He'll never have a problem reaching his audience, but I am concerned about, the more marginalized members of our society who don't have recourse, who are also being arbitrarily and discriminatorily suppressed on these platforms in ways that really harm not only their individual liberty, but also the social movements and causes that they're seeking to advocate.
So that's a great argument. I think we might have our first slight divergence here, which I think will be interesting for the audience. I share your concern about the power of social media companies. These are global companies, some of the biggest corporations in the world by stock market valuation, deciding the terms of democratic deliberation in our democracies. That's very problematic. I want us to talk about that and I want to hear what your suggestions are for what's a better model. But I think I might diverge a bit on the question of deplatforming Trump. The social media companies have terms of service. Those terms of service include hate speech guidelines and calling for violence, calling for targeting of specific minority, religious, racial groups is prohibited on those platforms. Many people have had their posts taken down and their accounts suspended or deleted altogether for a lot less than Donald Trump. There are people, I had a student in my class who said that his account was deleted because he came home and he said, I was looking forward to that cold pizza in my fridge all day, and it came back and my roommate had eaten it. And so I tweeted, I'm going to kill my roommate when they get home. And that was, there's no context in artificial intelligence. So they didn't get the context of that. They removed him. So my principle here is simply that the Donald Trumps of the world, the Rodrigo Dutertes of the world, the Bolsonaros of the world should not be given a free pass because they are political leaders. They need to be subjected to the same terms of service as anyone else. And if they violate them, they got to face the consequences just like everyone else. And I think the deplatforming maybe was a step too far. They certainly could have as they had done, label his tweets, which I think was valuable. They could have delayed his tweets, but on January 6th, I believe Donald Trump was still inciting the crowd as they stormed the Capitol building and represented a clear and present threat and danger to American democracy and society in the days thereafter. Okay, so what happens now is another story. We can talk about that, but I think the right decision was made at the right time, albeit by companies that are completely unaccountable to you and me.
We might have an area of potential agreement because it's clear to me that deplatforming altogether, apparently permanently, I mean, that's the equivalent of the death penalty, and seems to me to be not at all proportionate. And if it were a government doing it, it would be one of the most egregious violations of the First Amendment, a permanent prior restraint. Not allowing him to say anything, not allowing anybody to hear what he's saying on these platforms forever. But maybe what we lawyers would call a less restrictive alternative, such as you suggested, might have been a good way to go. By my clock, I think Ken is supposed to be giving the audience a chance for free.
I'm happy to jump in and we have tons of good questions, and I'm encourage people to put in more, but it's been just wonderful. I could listen to you guys forever and sort of make me want to go back to law school, which not too many people have that effect on me. So let me read you some of the questions and get some of your comments. There were many about Trump. I think you've answered most of them in passing, so I won't ask those, but here's one. A young charismatic politician is on the rise on American politics, promoting the view that, quote, Arabs are a disease in our society. Only a, quote, decisive solution, unquote, could cure, quote, America of this infesting danger. How should we address these words? What should we do, especially if and when we see the countering words with words do not stop the politician's meteoric rise to power? Whoever wants to go first, jump in.
Nadine, you want to go or shall I go? No, after you.
Please, no, please.
So first of all, this is a heinous post. It is offensive and reprehensible and unnecessary, but it's not criminal. And I think we need to recognize that disparaging a religious group and making vague references to dealing with them is not in itself a crime. Although we don't know the context of it. We don't know where it's being posted, and that does matter. So if there were a country where there were a widespread and systematic attack on a civilian population, let's say Arabs for purposes of, or whatever group is being referenced like this in the post, then it may deserve heightened scrutiny by the social media companies. And right now, they don't really have the mechanisms to do that. They have a single universal policy for the whole world. So I'll say that again. They make up their policy on hate speech in Palo Alto or some Northern California somewhere. They hand it to their engineers who write it into the algorithm, and the algorithm does 80% of the policing and removal. About 20% are human moderators. So I would like to see that that percentage changed more so that a more granular and contextual approach can be taken to that kind of speech, such that the social media company is more able to leave up speech that is reprehensible but not likely to lead to violence, and take down speech which is more likely to lead to violence. Say it's happening in the Rohingya situation of 2017. There was a genocide going on there against the Rohingya. And at that point, taking down that kind of post saying the Rohingyas, Islam is a terrible religion or whatever they were saying, the Tatmadaw, the Burmese military, it could have made sense for Facebook to take down those posts in the case of an ongoing genocide. So I think we can't opine on that in the abstract. We have to try and contextualize it. We have to push the companies to do a much better job of contextualizing their content moderation policies. I think there are a lot of other things we can do. I know Nadine is going to talk about them. She's going to talk about counter speech and a few other things. And I totally endorse those non-legal, non-regulatory measures as well. And they may be more important in the end.
And I'm just out of respect for other audience members, I will accept Richard's summary of the additional point. Yes, I mean, it's really, really important that we raise our voices, that we counter-organize, that we show support for the targeted groups and individuals, and do what we can to reach out to people who are tempted by this political rhetoric, including, I mean, common sense methods that social science has validated over and over and over again, which is to actually have interaction with the people who are being demonized and stigmatized, the so-called social contact theory. And actually, social media can play a positive role here because there's a lot of evidence that even parasocial contact, interacting with people virtually, or even seeing depictions, sympathetic, empathetic depictions of them in media, can break down those negative stereotypes.
Thank you both. So I'm going to combine two questions. One is, isn't part of the problem also that one person's hate speech can be another person's, quote, fair comment or even cutting edge humor? Give me an example of Michael Che on Saturday Night Live. And there's another question saying, I'm very concerned about Facebook and other platforms intending to deny the use of the term Zionism. I guess that's part of applying the working definition of anti-Semitism to regulate or flag comments about Zionism. Some groups are calling for that. So can you speak to those things? I mean, one person's hate versus another, and how you think social media should manage that.
This is the. I'm so sorry. You go first.
No. I was going to defer to you. I was saying, please take this.
Okay. This is the crux of the problem with government, or for that matter, social media regulation of hate speech. It is an inherently subjective, overly vague, overly broad concept. No two people can agree. One person's hated speech is somebody else's cherished speech. And I can give you real world examples. People have attacked Black Lives Matter as hate speech. People have attacked Blue Lives Matter as hate speech. People have attacked All Lives Matter as hate speech. On some campuses, the phrase free speech has been attacked as hate speech. Not to mention, the word Trump has been widely attacked as hate speech. So when you have an irreducibly subjective concept, the problem is whoever enforces it is going to enforce it either according to their own subjective values, if it's a politician, a government official, according to the preferences of the politically powerful groups in that community, if it's a social media company, in response to political pressures, in response to business concerns, in response to the values of the dominant shareholder of the company. And that is what gives the latitude to suppress unpopular voices and dissenting ideas. And I would make the same point, by the way, about the major other types of controversial speech that social media companies are being pressured to censor, namely disinformation and misinformation. We see that certainly in the context of COVID. One person's scientific truth, somebody else's plausible hypothesis, is somebody else's disinformation. And same thing with so-called extremist speech or terrorist speech, which is also a big subject for suppression. Going back to the old adage that one person's terrorist is somebody else's freedom fighter. In terms of, so the question about Zionism, maybe I'll kick that part of it over to you, Richard.
So Nadine is totally right. You know, if you ask somebody what hate speech is, what you do is you listen to all their biases and prejudices, you know, and what you hear is basically hate speech is the speech I don't like. And so we can't have that as a model for political deliberation, partly because things we consider now to be common sense, like don't enslave people, were once incitement on the books in about a dozen southern states before the Civil War, as an example. So many of the kinds of speech that we now don't even think about, you know, were once, people were put in jail for uttering those words. Another example would be in the 50s, there was a group of people put in jail for simply sitting around reading the works of Marx and Engels in Dennis, 1951. It's a Supreme Court case. And they were revolutionaries, and they were reading Marx and Engels and Stalin. And honestly, if I wanted to stop a revolution and I was a government, I would make people sit around and read Marx, Engels, and Stalin, because that stuff is boring. I read it in grad school, and it's like mentally stultifying. I mean, afterwards, you just want to lie down, as opposed to go out on the streets and start a revolution. But, you know, so they're changing mores, and we have to be very careful that we don't just allow the tyranny of the majority to squelch and suppress speech that is considered in the day to be offensive or reprehensible. But I worry, I agonize a bit more than Nadine does about this. I just get worried because I think actually someone's scientific truth is not another person's, you know, magical tale. I think actually science is more accurate than magical thinking about things, and that there are scientific truths that are very well founded in the evidence, and scientists are actually arguing about this stuff all the time. So they don't hold an absolute truth model. But I think we do have to have tests, and we have to make those tests as objective as possible. So most hate speech does not overlap with speech that is criminal, but some does. And there are three kinds: incitement, true threats, and defamation. Let's look at true threats. Sure, we could say one person's threat, true threat, is another person's joke. I didn't really mean I would come around and shoot you for stealing my pizza, okay? But courts do have to make these judgment calls, and we have to respect that. And we have to say that that is possible, although hard, very, very hard, that it is possible that a court would look at a fact pattern and examine the evidence and decide whether Anthony Alanis, this is a Supreme Court case from a few years back, really did threaten his ex-wife when he wrote rap lyrics about killing her on Facebook. In the end, they decided that they weren't true threats, and they came to that conclusion. But in a different scenario, they might have decided that it was a true threat. And I don't just want to get into this soggy relativist, well, one person's truth is another person's falsehood, so anything goes. I think we have to be more rigorous than that. We have to look at the law, we have to look at the evidence, and ultimately we have to make some very hard calls.
If I can say, Richard, I agree with everything you've said. And it's true that you cannot possibly eliminate all discretion. all interpretation. And so even a test as rigorous as the true threat test appropriately is, even a test as rigorous as Brandenburg intentional incitement, reasonable people can differ. But it's
Sure.
a whole lot less discretion than under the prior bad tendency test or a non-true threat, right? The true threat requires objective fear, not subjective. So the Supreme Court has greatly constrained discretion.
Yeah.
So I'm going to combine, I think, 3 or 4 questions into one. And this may be our last question because we're running short on time. So one is, what made the difference between Trump's speech that Richard referenced from 2016 and the speech on January 6th vis-a-vis incitement and hence illegality? One was that people on either side of this debate about whether he was doing incitement or not, some point to his use of the word peaceably, while others point to the number of times he said fight. Another person said, well, what's the difference between him using fight so many times and, as they put in the impeachment, the video of some of the Democrats using the term fight. And then the final question I'll weave into this is, how does this differ from the 1980s case against Tom Metzger and white Aryan nations, where he was found liable for the killing of an Ethiopian immigrant when his actions and words helped promote a skinhead gang that killed an immigrant with a baseball bat?
So the first part is definitely yours, Richard.
Okay. So Trump said a lot of bad things when he was running for office. He said, I'll pay your legal fees if these protesters, these Black Lives protesters were coming to his rallies, and he said, I'll pay your legal fees. He said, if someone throws a tomato, knock the hell out of them. But he also said immediately after, don't hurt them. I don't want anything to happen because they'll come after me. So immediately afterwards. And he sailed very, very close to the line. He knew where the line is. He's not a stupid man. And he has been calibrating his, what I believe to be racist speech for some time, to go right up to the line of incitement, but not cross it. I believe he did on January 6th, because his use of the word fight and fight like hell and don't be weak, and the Capitol building is right over there. March there now. I'll march with you, in order to prevent the certification of a free and fair election that he lost, I believe did rise to the level of incitement because of the place, because of the time. The previous 6 weeks of telling his followers that the election had been stolen, and the run up to that, I believe it's a different context than the kind of things he was saying in the 2016 presidential campaign. I think there are elements there that do meet the Brandenburg 3-part test of advocating violence, that violence being imminent and being likely.
Can I throw in one factor which supports the distinction Richard is making, which is that, and I'm not advocating it, I think there are a lot of complexities, and all of the facts have to be presented to the fact finder. But I would certainly not dismiss, to use a lawyer's term, on a First Amendment basis. I would say there's enough here that the fact finder should wrestle with it. And one additional legal factor, Richard, is that the Brandenburg test refers not only to imminent violence, but to imminent lawlessness. So
Right.
even if he did not intend to incite imminent violence, if he intended to incite imminent lawlessness, and including could be everything from trespass to assault, to other crimes that were taking place, that would satisfy the Brandenburg test. And having said that, let me leap to the last part of the question, and then maybe Richard, you can take the middle part of the question about the Metzger case. I don't remember the facts. Maybe you do, Ken. Yeah, you were in Oregon, I think, at the time. But I do remember this, which is very telling, that both sides asked the ACLU for support. And the ACLU said, we're, interestingly enough, it's very fact specific. We haven't done a factual investigation. What we will do is file a brief arguing to the court that it has to strictly enforce the Brandenburg test. And then we wrote, some commentary on all of the elements of the Brandenburg test. And, presumably the court followed that, but I can't attest to the particular facts.
Again, Richard, do you have, we're at 4 o'clock, so Richard, do you have any final words, or both of you final words on the large subject, which you both handled so beautifully? There's so much more to discuss. So I'll leave it to both of you to final words or answer anything else you'd like.
Well, final words. I feel I want to respect the third part of the question.
Okay.
That you had woven together, and it was somebody who was asking about Trump's specific words and to
Right.
what extent they should either be enough to find that he did commit incitement or did not commit incitement. And I think absolutely correctly, the court has said that you don't need explicit words of incitement. A dog whistle can be enough as long as the not stupid inciter, as Richard says, it can be reasonably found to have intended the inciting meaning, and as long as the audience can be reasonably found to have inferred that inciting meaning. And I think that's absolutely correct. And yet one more of the complexities for the fact finder in this case.
Richard, final words.
I would just like to add, thanks so much for the opportunity. I really enjoyed, especially listening to Nadine. I think it's incumbent on all of us to try and build a more civil culture of political discourse. And the criminal law, which we talked about a lot in the last hour, is a very brute instrument. And we want to use it only in the most special of circumstances. But there are all these other measures that we can take in our own lives. Counter speech, challenging racism and hate speech, education that is anti-racist, that tackles implicit bias, that teaches critical evaluation of information and evidence, better hate monitoring, monitoring of hate crimes. There's just so much more around this topic that we didn't get a chance to talk about, but actually is just as important or more important than the specific criminal law piece that is necessary component of, but to be used very rarely in countering hate.
Amen. And that's why we are so grateful to Ken and the Bard Center for the Study of Hate, because that's what you are fostering.
Yeah.
Anyway, thank you very much. And I really appreciate that last message. I mean, as lawyers, sometimes we get so focused on law as an answer to things, and sometimes it can suck away attention from other things that actually are much more effective to do to confront these problems, academic things, community organizing, other initiatives that I think really are ones that we should focus on more rather than defaulting to let's try to suppress it with law. Anyway, thank you both very much. I'm so looking forward to this. I'm absolutely delighted to have you both. And I look forward to some time when I actually have you both on the campus at Bard. Again, Nadine, you could wear the school colors if you wish. Richard, you don't have to, but it'll be great to see you there in person. And thank you everybody for attending. Have a great rest of your day.
Thanks, everybody.
Thank you.
Take care.
Bye.
Bye-bye.
Bye. Thank you.